Subcommittee will come to order. Without objection, the chair is authorized to declare a recess at any time. We welcome everyone to today's hearing on birthright citizenship. I will now recognize myself for an opening statement. As Supreme Court Justice Louise Brandeis once wrote, "The most important office, and the one which all of us can and should fill, is that of private citizen." This hearing is on the issue foundational to our republic. Who is an American citizen by birthright? Section 1 of the 14th Amendment grants citizenship to all persons who are, quote, born or naturalized in the United States and subject to the jurisdiction thereof, end quote. It is the latter clause, subject to the jurisdiction thereof, that we will examine today in significant part. Our inquiry is simple. What was the original public meaning of the jurisdiction clause? The 14th Amendment was drafted to rectify the terrible decision in the 1857 Dred Scott v. Sanford case by recognizing former slaves as rightful Americans. As we'll learn from our witnesses today, the answer is clear. The jurisdiction clause, as originally understood, grants birthright citizenship only to children whose parents have full exclusive allegiance to the United States. The constitutional text and history shows that children of illegal aliens and legal aliens who are in the United States temporarily are not citizens by birthright under the 14th Amendment. For decades, proponents of automatic birthright citizenship have claimed the 14th Amendment and the Wong Kim Ark case bestows automatic citizenship to all children born to foreign nationals, including illegal aliens. This is a blatant misunderstanding of both items, resulting in birthright citizenship serving as a driving force of illegal immigration to the United States, as many illegal aliens and temporary visa holders know they can reap the benefits of their child's citizenship. President Trump's first-day executive order on birthright citizenship restored the 14th Amendment to this original meaning. Despite what you may hear on the news, some of the most respected legal scholars agree with the constitutional interpretation outlined in President Trump's executive order. Some of these legal scholars include those here on this panel today. Our witnesses will dive into the history of the 14th Amendment in Congress and the Supreme Court, but I'll give you a brief version. The drafters of the 14th Amendment understood it not to grant citizenship to persons, quote, owing allegiance to any foreign sovereignty, end quote. And in the first cases decided after ratification, the Supreme Court held that jurisdiction in the 14th Amendment means not merely subject in some respect or degree to the jurisdiction of the United States, but completely subject to their political jurisdiction and owing them direct and immediate allegiance. Of course, illegal aliens and legal temporary United States residents do not owe complete, direct, and immediate allegiance to the United States, and therefore their children are not citizens by birthright under the 14th Amendment. Now, I'm sure we'll hear a lot from our colleagues on the other side of the aisle about Supreme Court precedent as well. So let us make one thing clear at the outset. The Supreme Court has never held that children of illegal aliens or aliens who are in the United States temporarily are entitled to birthright citizenship. President Trump's executive order is consistent with Supreme Court precedent. I'd also like to emphasize the purpose of today's hearing. We're here to discuss an important constitutional question. This is, after all, the Constitution Subcommittee, and I hope that we can keep our focus on the text and history of the 14th Amendment. But no doubt some of the policy implications will come up, and it would be a disservice not to at least mention those important issues implicated by the constitutional question. In addition to twisting the Constitution and court precedent conferring automatic citizenship is a bad policy. It devalues the meaning of American citizenship by bestowing it to the children of lawbreakers who entered the United States without the consent of its people, almost rewarding them for trespassing into our country's soil. To add context, an estimated 124,000 to 300,000 so-called anchor babies, which are children born to illegal aliens, are born each year according to the Center for Immigration Studies. In 2023, up to 250,000 children were born to illegal aliens in 2023, which accounted for 7% of total births in the nation that year. Moreover, it further strains government programs that are already strained. For example, in terms of supplemental nutrition assistance, SNAP, which provides school meals, Americans shell out $5 billion each year in SNAP and food stamps for the U.S.-born children of illegal aliens, according to a 2023 report by the Federation for American Immigration Reform. If one looks at the amount illegal aliens and their U.S.-born children are projected to consume in federal welfare program benefits, the American taxpayer foots an even larger bill. Take, for example, in a July 2024 report, the Congressional Budget Office that answers to us concluded that the federal government is projected to spend $177 billion in welfare benefits to illegal aliens and their U.S.-born children over the next 10 years. Now, mindful that is a larger population, but it is clear that the birthright citizenship issue implicates those issues. This $177 billion includes Medicaid, SSI, Obamacare premium tax credits, food stamps, and more. Ending universal birthright citizenship and thereby ending birth tourism, a practice in which pregnant women travel to the United States to give birth and secure citizenship for their children, is good policy. Birth tourism diverts U.S. medical resources away from our own mothers and babies and allows shady and unscrupulous birth tourism agencies, quote unquote, to prey on expectant mothers. According to a 2020 study, there are between 20,000 and 26,000 foreign tourists in the U.S. giving birth on our soil annually. As far back as 2008, the CEO of the McAllen, Texas Medical Center, where about 40% of births were to illegal alien mothers, stated that, quote, mothers about to give birth walk up to the hospital, clearly having just swum across the river in actual labor. Just as concerningly, adversaries like China are abusing universal birthright citizenship and practicing birth tourism to nestle deeper into U.S. society, which carries security concerns. In 2018, Georgetown Law's O'Neill Institute wrote the following, quote, women from foreign countries, mainly China and Russia, are paying tens of thousands of dollars to temporarily relocate to the United States during their pregnancy in order to give birth in the United States and thereby guarantee U.S. citizenship for their child. To shed light on the magnitude of this abuse, China hosts over 500 companies offering birth tourism services, resulting in more than 50,000 Chinese nationals delivering babies in the United States every year, according to a 2019 estimate. The Constitution does not require us to allow this practice, and we should not. Even late Senate Democrat Majority Leader Harry Reid recognized the disastrous policy implications of birthright citizenship as he opposed automatic citizenship for children born to foreigners. He said the following in a 1993 speech on the Senate floor, quote, if making it easy to be an illegal alien isn't enough, how about offering a reward for being an illegal immigrant? No sane country would do that, right? End quote. He continued, guess again, if you break our laws by entering this country without permission and give birth to a child, we reward that child with U.S. citizenship and guarantee a full access to all public and social services this society provides. And that's a lot of services. That is Harry Reid, the former Democrat leader in the United States Senate. Senator Reid was right in his observation. No sane country would enable a foolish policy like automatic citizenship to children born to foreigners, especially illegal aliens. Congress should heed his warning. Put simply, the framers of the 14th Amendment did not intend for universal citizenship to children born to all classes of foreigners. Nor did the judges in Wong Kim Ark case rule on the question of citizenship beyond the children of lawful permanent residents, including those born to illegal aliens and temporary visitors. And there's one more point I'd like to make in closing. Congress is where the debate over birthright citizenship should be happening. In fact, my friend from Texas, Representative Brian Babin, has legislation, the Birthright Citizenship Act, that would fix this policy gap and restore the practice of granting U.S. citizenship as was intended in the 14th Amendment. Section 8 of Article 1 and Section 5 of the 14th Amendment grant us power over questions of citizenship. President Trump's executive order rightly returns that power to us. And in doing so, it returns us to the reasonable common sense interpretation of the 14th Amendment when it was ratified in 1868. I now recognize the ranking member, Ms. Scanlon, for her opening statement.
Mr. Chairman, since this is our first hearing of the new Congress, I'd like to say that I am anticipating we will continue to have a vigorous exchange of ideas in this committee room, and I imagine we'll tackle some interesting and thorny legal disputes throughout this term. However, I have to admit that today's topic probably won't meet that expectation because for more than a century, there have been few legal questions as open and shut as whether being born in the United States makes someone a United States citizen. And this is a little bit of a spoiler alert here. I'll skip ahead and tell you right now, it does. Frankly, to suggest otherwise is nothing but a blatant and disingenuous attempt to rewrite our nation's history and the very words of the Constitution. Contrary to the chair's assertions, under the Trump administration, but it's one that Congress has a constitutional obligation to prevent rather than enable. So why are our Republican colleagues questioning the plain and long settled meaning of the Birthright Citizenship Clause? Simply put, it's because President Trump and his allies in Congress think there's something to gain politically by stripping an entire group of American citizens of their rights, their votes, their very identities, and turning them and their descendants into a permanent underclass. They want to decide who they deem worthy of being a citizen of our country and who isn't based on who their parents are and where their parents are from. And in an act of really cynical irony, they want to, in essence, resurrect the rationale behind the Dred Scott decision that the 14th Amendment was written to reject once and for all. Our history, our quest for a more perfect union, has always been about expanding opportunity and civic participation, not ripping it away. Broadening our electorate has been an important part of that progress, including through constitutional amendments that guarantee citizenship, enfranchisement regardless of race, women's suffrage, and more. And in doing so, we've sought to make our country and its government more representative, more fair, and more perfect. That's a goal, a vision that all patriotic Americans should share. Any attempt to radically reinterpret the Citizenship Clause serves only to further the goal of right-wing extremists to unconstitutionally limit who can have a political voice in this country. Donald Trump's unconstitutional executive order to end birthright citizenship, along with legislative efforts by Republicans in Congress to do the same, would drag us backwards, ensuring a government that's not for the people, but for some people. It's the absolute antithesis of the promise of America. It's been 150 years since the 14th Amendment enshrined birthright citizenship into the Constitution. In that time, the U.S. has been made better by the contributions of Americans born here to immigrant parents, regardless of where their parents came from or their parents' citizenship status. Overturning birthright citizenship would hurt our nation and deeply imperil our ability to continue striving for a better future. It would impact all Americans by creating a logistical nightmare. Bureaucracy would invade our maternity wards, with states and hospitals being forced to investigate which babies do or don't qualify for citizenship. More troublingly, though, ending birthright citizenship would create a legal caste system based on the status of one's parents. Instead of citizens, the U.S. would develop a permanent underclass of stateless, not legally recognized subjects who could be exploited or deported at the mercy of a political majority. That would be a twisted reflection of the intended purpose of the 14th Amendment, because the language chosen by the amendment's framers in the aftermath of the Civil War was to prevent this kind of caste system from ever returning. So if our Republican colleagues want to have a legal argument today, here it is. The American children of undocumented immigrants and the American children of those here on visas, such as for work or study, are indeed persons born here in America. At the moment of their birth, they're subject to the laws of the United States with an undeniable constitutional claim to the rights, duties, and protections of that reciprocal relationship. In other words, citizenship. The 14th Amendment's guarantee that all persons born in the United States and subject to the jurisdiction thereof are citizens of the United States, and that's the quote, clearly applies to those individuals. The plain text of that clause is about as straightforward a statement of American law as you can get. But there's additional support throughout the legislative history of this clause. In the debates on the passage of this amendment over a century ago, Congress clearly defined the intent and purpose of the Birthright Citizenship Clause and rejected the types of arguments being advanced against it today. Similarly, the Supreme Court considered and rejected arguments against the plain meaning of the amendment in the case of United States versus Wong Kim Ark way back in 1898. Subsequent cases have rejected the proposition being advanced by our colleagues today that the children of certain immigrants born in the United States should be denied citizenship because it's unconstitutional. Clearly, the law and history support the straightforward conclusion, and that's why 4 federal judges have already blocked the president's executive order attempting to end birthright citizenship. One of those judges, Judge Kuhnauer, a Reagan appointee, told Trump's DOJ lawyers the executive order was, quote, blatantly unconstitutional. In fact, he said in the courtroom, and I would hate to have been the lawyer on the receiving end of this, he had, quote, difficulty understanding how a member of the bar would state unequivocally that this is a constitutional order, end quote, noting that it boggled his mind. Flimsy arguments aside, ultimately, a president cannot unilaterally repeal a constitutional amendment. Any elementary student of civics knows the only way to repeal an amendment is with another amendment. Remember Prohibition? The 18th Amendment to the Constitution outlawed the sale and manufacture of alcohol in 1919, and it was repealed by the 21st Amendment in 1933. But there's the rub. Americans overwhelmingly support birthright citizenship. Presidents and extremists like Stephen Miller, who've championed the idea, know that they don't have the votes to pass a constitutional amendment to repeal birthright citizenship, much less get the approval of 3/4 of the states to make it law. So instead, they're trying to do an end run on the Constitution with a tortured and unconstitutional reading of the English language and more than a century of legal analysis. Our Republican colleagues are here today trying to enable the president as he pushes his wager that his Supreme Court, the one he stacked, will ratify his illegal attempt to amend the Constitution without the consent of the American people. As a Congress, as a government, as a nation, we should not be in the business of turning back the clock and allowing or pushing our country to backslide into the most shameful parts of its past. Instead, we should be passing laws that guide it toward the light of a brighter future, one in which our most fundamental American principles and the promise to form a more perfect union ring true for all, rather than just for a privileged few. And that more just, that more fair America and the policies that actually get us there is what I and my Democratic colleagues would rather use this committee to fight for. I yield back.
Not seeing either the chairman or ranking member, we will move forward and without objection, all other opening statements will be included in the record. We will now introduce today's witnesses. Mr. Charles Cooper. Mr. Cooper is the chairman and founding partner of Cooper & Kirk PLLC, a boutique law firm in Washington, D.C. He has spent more than 30 years in private practice and has argued 9 cases before the United States Supreme Court. He previously served in the Department of Justice and was a law clerk to Justice William Rehnquist. Mr. R. Trent McCotter. Mr. McCotter is a partner at Boyd & Gray PLLC, where he litigates in federal court and before federal agencies. He previously served as a Deputy Associate Attorney General, where he oversaw the department's civil, appellate, and federal programs branches. He also previously served as a federal prosecutor with the U.S. Attorney for the Eastern District of Texas. Of Virginia. Slip. It comes right out. Mr. Matt O'Brien. Mr. O'Brien is the Director of Investigations at the Immigration Reform Law Institute, where he oversees IRLI's investigations into fraud, waste, and abuse in the application and enforcement of the nation's immigration laws. He previously served as an immigration judge and in various positions with the Department of Homeland Security. Professor Amanda Frost. Ms. Frost is the David Lurton Massey Jr. Professor of Law at the University of Virginia. It's my undergraduate alma mater. Professor Frost's research focuses on immigration and citizenship law, federal courts and jurisdiction, and judicial ethics. We thank our witnesses for appearing today, and we'll begin by swearing you in. Would you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you are about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record reflect that the witnesses have answered in the affirmative. Thank you. Please be seated. Please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony in 5 minutes. Mr. Cooper, you may begin. Mr. Cooper, I think, is your microphone? Thanks,
Good
sir.
afternoon to members of the committee. I am especially pleased to be here to explore with you the meaning of 6 words of the Citizenship Clause of the 14th Amendment and subject to the jurisdiction thereof. The recurring debate over the meaning of these words boils down to a choice between 2 alternatives. Does it mean subject merely to the regulatory jurisdiction of the United States? That is, subject to the laws of the United States, as is virtually everyone on United States soil, including aliens who are here illegally or are here for the purpose of bearing a child to make it an American citizen? Or does the jurisdiction of the United States mean something more than that? the full and complete jurisdiction, requiring an allegiance that comes from a permanent lawful commitment to make the United States one's home, the place where one permanently and lawfully resides. I believe that this latter interpretation is compelled by the Citizenship Clause's text, structure, and history, as well as by common sense. I have time for just a couple of brief opening points. First, the text of the clause. If subject to the jurisdiction of the United States means nothing more than the duty of obedience to the laws of the United States, why did its framers choose such a strange way to say that? Why didn't they just say, subject to the laws of the United States? Doing so would have been quite natural, given that this straightforward, unambiguous phrase is used in both Article 3 and Article 6. The clause also ensures that birthright citizenship makes newborns citizens of both the United States and of the states wherein they reside. That is, where they live, their home. This word standing alone implies a lawful permanent residence, and it plainly excludes tourists and other lawful visitors, as well as illegal aliens who are prohibited by law from residing in a state, although they all must obey our laws. Second, the history of the clause. The clause was framed by the 39th Congress to constitutionalize the Civil Rights Act of 1866, which had been passed by that same Congress just 2 months earlier. The 1866 Act explicitly denied birthright citizenship to persons, quote, subject to any foreign power, close quote, and to, quote, Indians not taxed, close quote. It is clear from the debate in the 39th Congress that Congress decided to replace this language with subject to the jurisdiction thereof, not because Congress suddenly and without any comment decided to broaden the scope of birthright citizenship from the act. Rather, Congress was concerned that the phrase Indians not taxed language generated uncertainty about the citizenship status of the children of Indians, primarily rich and poor Indians. The dispute is best captured, I think, by this comment from Senator Trumbull, who wanted to replace the words Indian not taxed, even though he was the principal author of the 1866 Act. He said this, I am not willing to make citizenship in this country depend on taxation. I am not willing, if the senator from Wisconsin is, that the rich Indian residing in New York shall be a citizen and the poor Indian residing in the state of New York shall not be a citizen. This comment reflects two important points about the intended meaning of the clause by its authors, I think. First, they intended that the children of tribal Indians who resided on reservations and owed their direct allegiance to their tribes would not be entitled to birthright citizenship, but the children of assimilated Indians who had left their reservations and had established permanent residence among the body politic of the states would be entitled to birthright citizenship. Second, it is not at all plausible that the framers of the Citizenship Clause intended that tribal Indians to be able to evade this limitation on birthright citizenship for their children by the simple expedient of leaving the reservation long enough to give birth to a child. The key distinction between tribal Indians and assimilated Indians was allegiance. Tribal Indians owed their direct allegiance to the tribe, while an Indian who established a permanent domicile within the state and assimilated into the body politic committed his primary allegiance to the United States and thus entitled his children to citizenship at birth. The Supreme Court's 1884 decision at Elk against Wilkins confirmed this understanding essentially, ruling that the clause requires persons to be completely subject to the political jurisdiction of and owing direct and immediate allegiance to the United States. Make one final point. The Supreme Court's 1898 decision in Wong Kim Ark had nothing to do with the children of illegal aliens or aliens lawfully but temporarily admitted to the country. The court carefully framed the issue before it twice in verbatim terms as involving, quote, a child born in the United States of parents of Chinese descent who have a permanent domicile and resident in the United States. Thank you, Mr. Chairman.
Thank you, Mr. Cooper. We will now move to Mr. McCotter. I welcome you for your opening statement. I will note, Ms. Frost, we're going over a little bit of time. I'll give you ample time as well. Mr. McCotter, please proceed.
Chairman Roy, Ranking Member Scanlon, and distinguished members of the committee. The 14th Amendment confers citizenship on any person who was both born or naturalized in the United States and subject to the jurisdiction thereof. Each of those clauses invokes a specialized term of art. In other words, it doesn't mean what it might mean at first glance. For example, courts have held as recently as 4 years ago that those born in U.S. territories are not covered by the Citizenship Clause, despite being literally born in the United States. And similarly, for the Jurisdiction Clause, it invokes the historic doctrine of allegiance, meaning the person must owe direct and exclusive allegiance to the sovereign, as the D.C. Circuit held as recently as 2015. Now, the historical record for the Jurisdiction Clause is lengthy and complex. I would respectfully direct you all to the amicus brief that I submitted on behalf of many members of this committee, but I'll highlight 3 issues in particular. First, like Mr. Cooper, I'll emphasize the importance of the Civil Rights Act of 1866. There's widespread agreement that the Jurisdiction Clause of the 14th Amendment was meant to constitutionalize that act and that they mean the same thing. But of course, the 1866 Act excluded those who are subject to any foreign power. So that means citizenship for both clauses turns on not being subject to any foreign power. Senator John Bingham, who was later a principal author of the 14th Amendment, said, what does this mean? It means, quote, every human being born within the jurisdiction of the United States of parents not owing allegiance to any foreign sovereignty, end quote, would be a citizen. American birthright citizenship was reserved for those who were not already deemed allegiant to another sovereign at their birth. That takes me to my second point. You may have noticed in the quote from Senator Bingham that he refers to the parent's allegiance. Obviously, the 14th Amendment itself refers to the allegiance of the child. So what's the connection there? The connection is that at that time, and in many countries even now, the children born to citizens of that country were deemed themselves to be citizens of that country. For example, in English law at the time, a child born to English citizens in America would be deemed an English citizen at birth, and therefore could not owe complete and exclusive allegiance to the United States. That would deprive that child of being entitled to birthright citizenship. That's the connection between the parent's allegiance and the child's allegiance that you see so often. This leads to the third and final point to emphasize today. As Mr. Cooper said, as a matter of logic and history, the phrase subject to the jurisdiction thereof cannot mean subject to the laws thereof. The exceptions prove the point. There's widespread agreement that children born in the United States to ambassadors or to invading soldiers would not receive birthright citizenship. So it's not correct to say that all those born in the United States are citizens, even under those who challenge President Trump's executive order. As far as I'm aware, almost no one holds that view. The explanation given for why ambassadors' children and children of foreign soldiers are not entitled to birthright citizenship is often that those individuals are not subject to U.S. law. In other words, they have various forms of immunity. But that's wrong. Not even ambassadors have full immunity. At best, it's contingent. Their home country can revoke it. Nor are foreign soldiers immune from U.S. law when they are within the United States. So the inquiry cannot turn on parents' supposed immunity. As Mr. Cooper also pointed out, there's the fact that there was complete agreement at the time of the 14th Amendment that American Indian children would not be covered, even though they are undoubtedly subject to U.S. law and long have been. So the theory that subject to the jurisdiction thereof means subject to the laws thereof proves far too little. It cannot explain any of the categories widely accepted. It also proves too much. If it's correct that having a parent with contingent or partial immunity, as an ambassador would have, could deprive the child of birthright citizenship, then domestic individuals who have partial or contingent immunity, judges, prosecutors, even members of Congress who possess immunity for certain acts under speech or debate, would likewise fall within the same category. Of course, we know that's not right. We know that the children of those officials are U.S. citizens, while those of ambassadors are not. So what test explains the exceptions? It's allegiance, the first point I mentioned. Judges, prosecutors, members of Congress, they're all fully allegiant to the United States. Ambassadors, foreign soldiers are not. So the takeaway for this committee, Congress can confer citizenship by statute and has done so for many groups not covered by the jurisdiction clause, including Indians and those born in many of the territories. But that power is and always has been exclusively Congress's alone to exercise. Thank you.
Thank you, Mr. McCotter. Mr. O'Brien, you may proceed.
Chairman Roy, Ranking Member Scanlon, members of the committee, it's a privilege to appear before you today, and I thank you for the invitation. The two witnesses before me, I think, have very ably summarized what's at issue here. So what I would like to point out is two things based on my many years of experience working in immigration law directly. I actually began my career as an immigration examiner in the naturalization division of the INS, so I'm very familiar with these issues. Now, it's very easy to say the meaning of this case is obvious. Of course, if it were obvious, it probably wouldn't have had to become a case in the first place. The common narrative goes something like this. Wong Kim Ark means that everyone born in the U.S. gets citizenship. Later in Plyler v. Doe, Justice Brennan confirmed this in that holding, stating that no plausible distinction with respect to the 14th Amendment jurisdiction can be drawn between resident aliens whose entry into the United States was lawful and resident aliens whose entry was unlawful. There's two major problems with that approach, though. The first is that the court in Wong Kim Ark couldn't address the question of citizenship being conferred upon illegal aliens because there were no illegal aliens to speak of at the time. U.S. immigration law barred a very small slice of individuals, among them Chinese nationals who were subject to the provisions of a treaty between the United States and China, criminals, and people who were likely to become public charges, as well as those who appeared to be clinically insane. So the concept of illegal aliens was one that wouldn't come along until much later. At that point in time, anybody who could pay the 50-cent admission tax, entrance tax, could be admitted to the United States and was permitted to remain there indefinitely. Now, the second problem with the standard narrative about Wong Kim Ark is that Justice Brennan's assertion in Plyler v. Doe is obiter dicta, a judge's incidental expression of opinion that is not essential to a decision and does not constitute part of the precedent established by a case. In that case, in a footnote, Justice Brennan expressed his personal opinion that a 1912 immigration law treatise, not case law or statute, held that everyone born in the U.S. was a citizen. In short, neither Wong Kim Ark nor Plyler had anything to do with whether the children of illegal aliens become U.S. citizens at birth. In fact, that question has not yet been addressed by the Supreme Court, and there's little basis on which it may be argued that the holding in Wong Kim Ark would require a conclusion that the children of illegal aliens are automatically entitled to citizenship upon being born within the confines of the United States. If the United States is to formulate a reasonable policy for the transmission of citizenship, then it must abandon the dangerous folktale that is currently associated with Wong Kim Ark. And I hope that my testimony here today will assist this committee in getting to the heart of what Wong Kim Ark and the 14th Amendment really require. And if one stops and thinks about this, it would be utterly irrational to lay out a list of people who are inadmissible to the United States and whose presence here is unlawful, which can result in their criminal prosecution as well as their removal from the United States, but then allow those people to transmit citizenship to their children unquestionably and without any qualifications. So I thank you for inviting me here today.
Thank you, Mr. O'Brien. Appreciate your testimony. Ms. Frost, you may begin.
Chairman Roy, Ranking Member Scanlon, and distinguished members of the committee, thank you for the opportunity to discuss the significance and meaning of the 14th Amendment Citizenship Clause. Some provisions of the U.S. Constitution are broad and confusing, but the Citizenship Clause is not one of them. The text, the drafting history, the original understanding, and over a century of unanimous judicial precedent and historical practice all confirm that the Citizenship Clause means what it says. As the text states, The Citizenship Clause grants citizenship to all born in the United States, and the only meaningful exception today is for the children of consular officials. The Citizenship Clause was intended to remove the stain of Dred Scott from our Constitution, the Supreme Court decision that held citizenship turned solely on race and ancestry and not birthplace. In 1868, the nation rejected Dred Scott. And when discussing this addition to the Constitution, the Reconstruction Congress explicitly stated that it wanted to provide citizenship to the 4 million formerly enslaved Americans and the children of immigrants arriving from around the globe. This Congress also acknowledged and well knew that some of those enslaved Americans had been brought into this country in violation of the law, because laws after 1808 prohibited the international slave trade. These were the illegal aliens of the day, and thus it is wrong, as Mr. O'Brien just stated, to say that there wasn't such a thing as an undocumented or illegal alien at the time. The Reconstruction Congress well knew there was, and of course intended to grant those people citizenship. That is why President Trump's executive order has been rejected by every federal court that has addressed it over the last month, 5 and counting, and these judges have been scathing. Federal Judge John Kuhnauer, appointed to the bench by Ronald Reagan, described the executive order as blatantly unconstitutional. Federal Judge Joseph LaPlante, a George W. Bush appointee, enjoined the executive order on the ground that, quote, it contradicts the text of the 14th Amendment and the century-old, untouched precedent that interprets it. These judges have concluded that the Trump administration's arguments in favor of the executive order are ahistorical, atextual, and illogical, also inconsistent with the order itself. For that reason, I'm not going to spend any more of my time here discussing the meaning of the Citizenship Clause, which is detailed in my text of my written statement, and I'm happy to answer questions. But instead, I'm going to move on and talk about the devastating consequences of this executive order for the 3.5 million American families who every year welcome a new child into their family. The executive order claims the power unilaterally to rewrite the Constitution. That alone is disturbing enough. In doing so, it excludes hundreds of thousands of newborn children from citizenship, including the children of immigrants who came legally to the United States. All of these newborn children would be declared undocumented immigrants from the moment they are born. Some would be born stateless, and all would be at risk of being deported away from their parents and denied all the rights and privileges of citizenship at the most vulnerable moment of their new lives. Worse, if this were to go into effect, it would not be limited to the people carved out by the executive order, that is, the children of undocumented immigrants and the children of temporary immigrants. It would affect all Americans, every single person giving birth to a child going forward. All would now have to produce paperwork proving their status, their citizenship, their green card status at the time of the child's birth. And as an immigration lawyer, I will tell you, for many people, that is not easy. I thought this was a committee that favored limited government. This is expanding the federal bureaucracy and the paperwork burdens on these families, hospitals, state agencies, and overburdened immigration officials, as I said, at the most sensitive moments of these people's lives. As explained, the executive order is not only unconstitutional, it is not only a terrible policy, it also conflicts with fundamental American values. We are a nation that rejects the test of ancestry and lineage, and we prefer instead to grant citizenship based on birthplace. That's a choice we've made well over a century ago. To be born in America is to be born an equal citizen. America is excellent at integrating the children of immigrants into our society. It is one of our great strengths. All Americans should be proud that in 1868, the nation rejected Dred Scott and reclaimed citizenship based on location of birth, not lineage and ancestry, welcoming the children of immigrants. We must never go back.
Thank you, Ms. Frost. We will now proceed under the 5-minute rule with questions. The chair recognizes the gentlelady from Wyoming for 5 minutes.
Thank you, Mr. Chairman. Birthright citizenship allows for predatory birth tourism practices in which foreign-born women come to the United States on tourist visas to give birth so that their children become U.S. citizens. Once the children turn 21, they can sponsor their parents to become legal U.S. residents so the family can immigrate to America. Concerningly, the majority of these birth tourists come from one of America's greatest adversaries, including China. Because of advances in technology, lax surrogacy laws, and the incorrect understanding of the 14th Amendment, countries are now using international surrogacy programs to rent wombs in America. Mr. O'Brien, there is a back and forth in U.S. policy regarding scrutiny and restrictions for birth tourism, including 2 different policies issued in 2015 and 2020. Where does our federal policy currently stand on this issue, and is it strong enough to prevent this practice of essentially renting wombs for surrogacy to have anchor babies?
Well, the fact is that we don't have any policy specifically on this. We have the immigration laws, but as we've seen with the last administration, if the government refuses to enforce those, they have no effect whatsoever. And there's anywhere from 125,000 to 300,000, depending upon whose estimates you're looking at, incidences of birth tourism each year. The implications of this are absolutely frightening if you look at it long term. During the Cold War, the Russians had a program called the Illegals Program, where they inserted agents of influence and spies into the United States with documents that made it appear that they were lawfully here. If those people had children, they became U.S. citizens, and regularly those children were trained, despite the fact that they allegedly had a claim to United States citizenship, they were trained to be against the interests of the United States. So this is something that is dangerous. We need a firm policy against it. And it is something that places the United States at a great deficit in terms of national security.
Well, and I want to focus specifically on this issue. According to the Heritage Foundation, they have reported on a new birth tourism tactic which uses international commercial surrogacy to exploit America's misinterpretation of the 14th Amendment and our lax surrogacy laws. Intended parents who are foreign nationals use a surrogate in or transported to the United States, and the surrogate may be an American woman who then gestates a child for a fee, allowing foreign nationals to essentially rent a room or buy a baby. Mr. O'Brien, under the current wrongful interpretation of the 14th Amendment, this child would gain U.S. citizenship, wouldn't they?
Yes, they would, and because the Immigration and Nationality Act has become a muddle under the weight of misinterpretations about various effects of provisions of the Act, that places the United States in a position where people with no connection to the United States who simply want to be here because they either don't like the political or economic conditions in their home country can then use the citizenship of an adopted child or a surrogate child to try and access the United States and then eventually get lawful permanent residence and become citizens themselves. So
this form of birth tourism actually exacerbates the crisis we have with birth citizenship requiring direct and exclusive allegiance, which should require direct and exclusive allegiance to the United States. Don't you agree?
Yes, it does. It exacerbates it significantly.
Well, what's very interesting is China banned international surrogacy, yet the international industry is disproportionately fueled by Chinese nationals who make up 41.7% of this surrogacy industry. Should this raise national security concerns that China is aggressively participating in a practice that it has banned in its own country?
Yes, China has an established pattern through an organization called the People's Work Bureau of approaching people who have a familial connection to China, regardless of their citizenship, and then pressuring them based on connections to Chinese family members who are still within the PRC to provide intelligence information, whether that be national security information or economic espionage information.
Well, and what's interesting is that these children who are receiving American citizenship, they receive that even if the parents intend to raise them abroad. What are the benefits of having a child with American citizenship?
Well, the benefits of having a child with U.S. citizenship is that child can later sponsor you for lawful permanent residence. It also makes the child eligible for all sorts of things that come along with U.S. citizenship, which is entering and leaving the United States. The implications of that from a national security or criminal perspective are enormous. So this is truly frightening. And it's shocking to me that there is so much debate about this. I think if we're arguing about this, we've sort of lost the concept of what citizenship is and what it means.
Amen. I think you make a very good point. I ask unanimous consent to put into the record an article from July 15, 2024, entitled "The New Face of Birth Tourism, Chinese Nationals, American Surrogates, and Birthright Citizenship." And with that, I yield.
Without objection. Also without objection, Mr. Biggs will be permitted to participate in today's hearing for the purpose of questioning the witnesses if a member yields him time for that purpose. I will now recognize the gentlelady from Washington, Ms. Jayapal.
Thank you, Mr. Chairman. Let me be very clear. Donald Trump's executive order to eliminate birthright citizenship is, quote, blatantly unconstitutional. Those are not my words. Those are the words of Judge John Kuhnauer, a Reagan-appointed federal judge from my home state of Washington. The judge went on to say that while, quote, the rule of law is, according to Trump, something to navigate around or something to be ignored, whether that be for political or personal gain in the courtroom, the rule of law is a bright beacon which that judge intends to follow. For over 100 years, birthright citizenship has been enshrined as a fundamental right under the 14th Amendment. The language in the amendment is very clear. All persons born or naturalized in the United States. In fact, so clear that at least 4 federal judges have concluded that the executive order is unconstitutional. Like many of the attacks on immigrants by the Trump administration, this attack centers on old tropes that question the, quote, allegiance of immigrants, tropes that were applied to enslaved Black people brought to this country in shackles, as well as Japanese Americans imprisoned and interned during World War II. These attacks are couched in a completely baseless argument that somehow immigrants born in the United States to a parent who is undocumented don't have sole, quote, allegiance to the United States. Professor Frost, this argument is actually very similar to the very arguments made in 1897 by Solicitor General Holmes Conrad in the Supreme Court case United States versus Wong Kim Ark, when he argued that the children of Chinese immigrants were not, quote, subject to the jurisdiction of the United States because they owed their allegiance to the Emperor of China. And the Supreme Court considered these racist arguments and they categorically rejected them, correct? Can you explain why, if that's the case?
Yes, that's correct. I think it's worth noting that Holmes Conrad came from a slave-owning family. He was an officer in the Confederate Army, and he himself lost his citizenship for a period of time because he was a traitor to the United States of America. In addition to the argument you just noted that he made that stated that the children of immigrants, and in particular Chinese immigrants, did not have allegiance to the United States, he made that argument explicitly, and it was rejected by the Supreme Court in 1898. But in addition to that, I think it's worth noting, he also told the Supreme Court of the United States that the entire 14th Amendment was unconstitutional. That's an argument he made. I'm not aware of ever a Solicitor General making that argument to any other Supreme Court in the history of the United States. And of course, the Supreme Court rejected that as well. So that argument's been made, and it's lost 127 years ago, and it will fail again today, as it already has in front of 5 federal courts.
And at that time, the Supreme Court held that the phrase "subject to the jurisdiction thereof" was an extremely narrow qualification that only accepted 3 specific classes of persons from citizenship. So can you tell us what those 3 classes were and why they do not apply and implicate children of undocumented immigrants?
Yeah, so the Reconstruction Congress was very clear. The Supreme Court agreed in Wong Kim Ark and subsequent cases that the "subject to the jurisdiction thereof" language applied to 3 groups. One was the children of diplomats and consular officers, for the obvious reason that the French ambassador to the United States doesn't want their child born in the U.S. to be a citizen, and their situation in the United States is they're representing a foreign power. In fact, the embassy itself is considered foreign territory. Native Americans, that was the only really substantive discussion the Reconstruction Congress had. At the time, they suggested this addition of the Citizenship Clause to the 14th Amendment. And they pointed out in many discussions that the Indians, Native American tribes, were sovereign powers with whom we had treaty relations, who were not subject to U.S. law. They had their own tribal courts and laws. And at that time, they wanted to be excluded, and the Reconstruction Congress didn't want them to be automatically included. I should note that there is now a federal law that gives Native Americans automatic birthright citizenship. The final group, I'm happy to say we've never encountered, which is enemy aliens in occupied territory.
Great. I'm gonna stop you just because I have another question here. One of the lawsuits blocking the order was brought by an individual in my state, Alicia Lopez. She was born and raised in El Salvador, but she fled the country after experiencing a violent and abusive situation. She had applied for asylum, has received a work permit while her application is pending. She's lived in Washington state since 2016. She has a 5-year-old son with her partner. She's pregnant with a second child who is due in July. I want to bring this back to the real impact of what would actually happen. Birthright citizenship has generated this deep sense of membership in our society, a collective commitment to a shared value and opportunity, equality, and contribution that's allowed America to thrive. What's the impact on real-life Americans across this country?
Yeah, to eliminate birthright citizenship would be to create a permanent underclass, a caste system, which was the very result the Reconstruction Congress intended to end.
Thank you so much. I yield back, Mr. Chairman.
Thank the gentlelady from Washington. I now recognize the committee chairman, Mr. Jordan.
I thank the chairman and thank you for holding this hearing. I would yield my time to the gentleman from Arizona.
I thank the gentleman for yielding. I'm going to ask each one of you a question related to this scenario, because this is a real scenario. In Yuma, Arizona, they have one hospital for about 150,000 people. They have a small maternity unit, about 8 to 10 beds. Many times the beds, every one of them is occupied by a mom-to-be who has illegally crossed our border, usually through the Cocopah Reservation. I know right where they come, and they go in, and they have a baby, and then they both depart to go back south across the border. And I guess my question for each one of you is this. Under the original meaning, because I'm trying to establish, you've all made it clear, I want to make it clear. Under the original meaning of the 14th Amendment, Ms. Frost, is that child a citizen of the United States of America?
Yes, of course, because the
Okay,
Reconstruction Congress wanted in simple and clear language.
Thank you, appreciate that. Oh, and now, Mr. Cooper?
No, Congressman, not under the citizenship clause of the 14th Amendment.
Mr. McCarter?
I agree with Mr. Cooper, that's correct.
Mr. O'Brien?
No, because she's not lawfully present in the United States, the mother.
So let's consider, we have a very, very disparate interpretation of Wong Kim Ark. We've got Ms. Frost, whose position, and I don't want to misstate it, but that the original allegiance or the jurisdiction thereof displaced the allegiance requirement, right? So there's no more allegiance requirement. Is that fair? Is that a fair description of what you're saying, at least on that portion?
I'm not sure what you're referring to by the original allegiance requirement. There was never an allegiance requirement. There was the Dred Scott decision.
Okay, so that's what I'm getting at. You believe there was never a jurisdiction thereof never required allegiance to the sovereign. And so now I want to clarify that. When you get to that, Mr. McCarter, why is it that in Wong Kim Ark, the court said that the plaintiff or the appellant in that case was actually a citizen of the United States?
The Supreme Court's rationale is a little hard to follow in Wong Kim Ark, to be honest, but it does say that the parents there were lawfully present with the consent of the sovereign, which is the United States, the equivalent of our modern-day LPR, lawful permanent resident.
So if because that's the way I read Wong Kim Ark. They're talking about there's lawful presence, and there's an intention de domicile, which has a legal term of art, meaning you're intending to live there, stay there, and be part of that community. That's really what that gets at. So I'm baffled by the notion then that if you cross through the Cocopah Reservation and you go into the regional hospital in Yuma and you have a baby and your intention is to immediately leave and go back home, you're not legally present in the United States, nor do you have an intention to be here. Why then does that baby entitled to birthright citizenship, Mr. Cooper?
Sorry, Congressman, that baby is not entitled to birthright citizenship. And I think Wong Kim Ark does not in any way support the claim that it's entitled to birthright citizenship. As I mentioned previously, the issue in that case was very clearly limited to aliens who had established a permanent and lawful domicile in this country. So whether you think that's sufficient or not, it clearly doesn't sweep within it people who have come into this country illegally. And I would also point out, Wong Kim Ark itself said there are some certain irresistible conclusions to be drawn from the Citizenship Clause, including that the 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory in the allegiance and under the protection of the country. And the reason they concluded there.
And I have to go there because I want to go real quick because it actually segues from that nicely. And that is one of the things, and actually Ms. Frost she indicated this. When in the Indian tribe case, when we look at that, is because there was respect for a tribal Indian having an allegiance to that tribe. That's very different than someone who crosses over, has a baby, and returns to their native country. Isn't that true? Mr. O'Brien, I'll go to Mr. O'Brien.
Yes, that's true. And in Wong Kim Ark, what the court did was they inferred that long-term residence was an intention by someone who was working towards citizenship and wanted to be a long-term member of the community in the United States. So the court was at pains to point out that there were two qualifications. One, that the individual attempting to transmit citizenship had to be lawfully present in the United States with the permission of the government. And number two, that that person was within the allegiance of the United States, meaning that that individual had more than a simple obligation to obey the laws while present.
Thank the gentleman from Arizona. I thank the witness, and I will now recognize the gentleman from New York, Mr. Goldman.
Thank you, Mr. Chairman. Mr. O'Brien, I want to go back to where you were right there. And I think Mr. McCotter said this as well. Your interpretation is to be lawfully present in the United States with consent of the sovereign. Mr. McCotter said that's the equivalent of a lawful permanent resident. Is that correct, Mr. McCotter?
That's correct, yes.
And you agree, Mr. O'Brien?
Yes, I do.
Why is a visa holder not lawfully present in the United States with consent of the sovereign?
Well, first of all, a visa holder is a person who has a permit to board a common carrier and come to the United States and request admission. A person who has been admitted to the United States by the appropriate authorities following inspection by an immigration officer is lawfully present.
So someone with a visa, a work visa that could go on for years and years, you're saying is not lawfully present?
No, that's not what I said at all. I said a person who has been admitted in a visa classification, like H-1B, F-1, so on and so forth, is lawfully present while they're in compliance with the terms of the immigration laws.
Okay, so I agree, but you're trying to restrict this to green cards. And the problem that I'm addressing here is this executive order is not restricted to green cards. It prohibits birthright citizenship if neither parent is either a lawful permanent resident or a United States citizen. Do you agree with that, Mr. O'Brien?
Yes, I do. The court in Wong Kim Ark.
So in Wong Kim Ark, exactly, in Wong Kim Ark, they used the definition you just said, which would include visa holders, and yet the executive order expressly excludes visa holders. So let's move to the second point, allegiance. This is what the subject to the jurisdiction thereof that you all three of you have talked about relates to allegiance. I'd love to see a clear and definitive definition of allegiance, but let's just talk about what you all were saying. Allegiance means assimilated. Is that correct, Mr. Cooper? That's one of the things that you said?
I think that only a person, or at least an Indian, under the view of the framers of the Citizenship Clause, who had been assimilated and had left the reservation and therefore had essentially abandoned that person's allegiance to the tribe and had shifted their allegiance to the United States, just like others could have a child.
So if you move off of a tribal reservation and you move across the street at the time, where you're talking about, originalism here, and you move across the street, then all of a sudden your allegiance has changed from the Indian tribe, the Native American tribe, to the United States. That's what you're saying. Do you disagree with that?
I do disagree with
Okay.
that. I think the notion.
Is there a time requirement? You must live off of the reservation for 1 year, 2 years, 5 years?
No.
No, there's not. So this is the problem, is you start talking about allegiance and you're excluding green card holders. Now, green card holders, of course, are also citizens of other countries. And yet somehow in this definition of allegiance, that a green card holder has more allegiance to the United States than that person would to, by necessity, by definition, than that person would to a foreign country. That seems like a pretty bold statement to be asking the Supreme Court to say. And what scares me about it as an American Jew, when Jews are often accused of dual loyalty with Israel, is you're now getting into a situation where the government has to determine which country any individual has more allegiance to. The country that they have immigrated to, and even if they're a lawful permanent resident, or the country of their citizenship. And it baffles me that the Republican Party, the party of small government, the party of federalism and states' rights, would sit here and say, yes, it is the government's job to create a definition of allegiance which somehow is required in order for birthright citizenship. Now look, Mr. Biggs, and you may not like the example, birthright tourism you call it, of someone coming into the United States, having a baby, and then leaving. If you don't agree with that, that's fine. Pass a constitutional amendment, because this is clear, and this definition that you're providing is unbelievably vague and very, very careless, and I look forward to the courts rejecting it. Thank you. I yield back.
Thank the gentleman from New York. As individuals who recite the Pledge of Allegiance down on the floor of the House of Representatives, every time we open the House, I think those of us understand what allegiance is, particularly the gentleman from Texas who wore the uniform of our armed forces. I think he's fully aware of what allegiance is. And I would also note that one of the very few responsibilities our federal government has is actually making those determinations as to who should be citizens and who should be in our country.
Correct.
I would now recognize the gentleman from Texas.
Thank you, Mr. Chair. I understand more than anyone that we are a nation of immigrants, but there's a difference, stark difference, between giving citizenship to the children of slaves, the children of those subject to the Middle Passage, the children of sharecroppers, and the children of those who were once considered property, and giving citizenship to the children of people who crossed the border illegally, stay in taxpayer-funded luxury hotels, who receive free Xboxes, free cell phones, free flights around the country, and 3 square meals a day. There's a big difference. My great-great-grandfather was born on a plantation, Rosedown Plantation in Louisiana. He had to join the Union Color Guard to gain his freedom. By morphing the Citizenship Clause into something that it wasn't meant to be, it's demeaning to descendants of slaves like me. And not just me who served this country, but my father is a retired colonel. My sister went to West Point as a retired colonel. My brother went to West Point. We are talking about a direct descendant of a slave that earned the right to be in this country and passed that ilk down to his ancestry. People bled for it. People died for it. And it means something. The purpose of the 14th Amendment that President Trump's birthright citizenship executive order is that the citizenship clause of the 14th Amendment was never meant to apply to children of illegal or legal aliens. Allowing birthright citizenship to stay in place dilutes the citizenship of not just Black Americans like me, but every single American citizen that had to earn it the right way. Let's say this in black and white. Either you're a U.S. citizen or you are not. Now, the left has spent decades cheapening what it means to be an American citizen. They've quite literally been chipping away at the basic value of American citizenship. They pretend to be altruistic, but we know the truth. Ozzy Osbourne's daughter said on The View that we have to let illegal immigrants in this country because who else will clean our toilets? We hear it all the time. Who will pick our crops? And even though that we know that American citizens are the majority of those people picking our crops, we know what you're insinuating. And all this must end now. Mr. O'Brien, earlier you brought up birth tourism and how it's an issue of national security. Could you kind of expound on that and talk about why that's an issue? As somebody that served this country, this is near and dear to my heart.
Sure. If we give U.S. citizenship to absolutely anyone who is born on our soil, that takes the United States out of control of who becomes a U.S. citizen. And since, as everyone here knows, the people are the government of the United States, that puts us in a position where we could be allowing people who are citizens of adversary nations to be coming here, having children who gain U.S. citizenship, and then are trained to be adversaries of the United States. It puts them in a position where they can get jobs with security clearances, they can join the military, they can work in the defense industry, which they would not otherwise be able to do.
So over the course of the last 4 years, have there been people that have entered our country that are our adversaries, that have come to this country that we know of, and had children?
Yeah, there have been a massive number of people who have come here. And not just over the last 4 years, it was happening before. I worked in the national security apparatus of the Department of Homeland Security, and I worked on many cases where that had happened.
Is there any other country in the world that you know operates like this? I'm saying this from the standpoint of somebody that's deployed to Saudi Arabia and other countries around the world. This would never happen anywhere else, by the way. Can you name a country in modern or recent history that has behaved like this, and what has been the outcome of this type of behavior? Meaning that is this even a sustainable model given the number of people that have entered this country over the course, especially the last 4 years?
No, it's not a sustainable model. The only other place where it existed was in a number of the Latin American countries, and most of them did away with it after they were attempting to attract migrants in order to build their industries and build the number of people living in those countries. So this is something that's nearly non-existent.
Thank you, Mr. Brown. The left throws love thy neighbor in our face, and they say that we have to have open borders in order to be nice to people. Well, I ask them to tell the left, we have a bunch of neighbors right here in our country that are Americans. You see, your neighbors are the homeless veterans that you drive by to work. Our neighbors are the wayward teens running away from a bad home environment. Your neighbors are the families who just got evicted from their apartment. What do all those neighbors have in common? They're all Americans. And let's use our American tax-paying dollars to put Americans first. Newsflash, this is why President Trump is our president, because it's past due that we put the American citizen first. And once we solve our issues here, I'm a Christian. By God, let's help everybody else. But at this point, we have enough problems to fix in our own country, and this must stop. Thank you for your time.
Thank the gentleman from Texas. I will now recognize the gentlelady from Vermont.
Thank you, Mr. Chair. Today we've heard a lot of different legal theories about interpreting the Constitution, and at times I know it feels a little bit like a law school lecture. So I'd like to kind of cut through the legalese and clearly focus on something that I find deeply troubling. What Republicans are offering is a plan to redefine who gets to be American. And it's a big step towards a country where Americanness itself applies to only a privileged few, and a country where future and past generations are relegated to an underclass status. They're trying to stake out who is a real American, and it will leave a whole lot of people out. And this, I think, is a frightening road to go down. The arguments we've heard have been with us since our founding. As you pointed out, Professor Frost, The Dred Scott decision changed the common law understanding of birthright citizenship for all. It enabled slave owners to use the law to take away citizenship, to take away identity, to take away the freedom of Black people. The 14th Amendment and the Civil Rights Act of 1866 were a direct response to Dred Scott. The law grants citizenship to people born in this country, plain and simple. Yet here we are, over 150 years later, talking about how maybe the straightforward language of the law could possibly or should actually be used to deny citizenship for often people of color. Ms. Frost, did the framers of the 14th Amendment intend to extend birthright citizenship to the children of slaves and other non-citizens?
Yes, the Reconstruction Congress could not have been clearer. They used clearer language, and their discussions that followed made this clear. They said, of course, they wanted to overrule Dred Scott, which included giving citizenship to all enslaved Americans, including those who had arrived illegally because they'd been illegally imported after the laws prohibited it. They were the illegal aliens of the day. The Reconstruction Congress said, we want them to have citizenship. The second group, explicitly discussed, was the children of immigrants, in particular, the children of Chinese immigrants. That was the intention of the Reconstruction Congress, and they achieved that through clear language.
Thank you. Through clear language. And citizenship was based on where you were born, correct? And not actually the identity of your parents.
Of course. We are a country that doesn't visit the sins of the father on the child. We believe in the idea that all people born are equally American because they are born in the United States. Our Constitution rejected titles of nobility explicitly. We, of course, rejected a hereditary monarchy. America is about birthplace. It's not about ancestry or lineage.
So is it safe to say that the 14th Amendment enshrined citizenship for an entire class of people and their ancestors?
Yes, of course. And any other rule would require a test of lineage and ancestry for every new child born in the United States. I'd like to quickly add 33 countries have birthright citizenship in response to Congressman Hunt's question, including Mexico and Canada. We are not outliers.
Exactly. I'm so glad you brought that up because I had it in my notes to bring that up as well. So what if the Supreme Court decides that the 14th Amendment actually does not give citizenship to children born in this country to non-citizens? What if the Supreme Court made that ruling? Where does that leave the descendants of those who've been granted birthright citizenship?
Yeah, I mean, it would unwind the citizenship of the entire country. We are a nation of immigrants. A very significant majority of us trace back, really other than Native Americans, trace back our lineage to an immigrant, parent, grandparent. 5% of our military are the children of immigrants. Now, all of us, when we have a baby, the first thing we'd have to do is produce proof of our citizenship. Imagine a generation from now. It wouldn't be good enough to show your own birth certificate. You'd have to show the lineage. This is exactly what the Reconstruction Congress wanted to prevent, and it's exactly the result that Dred Scott wanted.
I appreciate that so much. So let's follow this logic. Say a person's grandparents came to this country from Central Europe in the 19th century. An investigation reveals that those grandparents used false pretenses or false names at Ellis Island. Does that mean, based on what my colleagues would be saying today, that the present-day descendants of those grandparents are not citizens?
The logic of the position is that every single person who considers themselves an American, perhaps people in Congress, certainly people voting, would suddenly be under scrutiny, and any flaw in their family's immigration history, going back to the Contract Labor Act of 1885, where if you came to the U.S. with a contract to work, that was illegal. Many people violated that law in 1885. All of those people, their descendants today, could have their citizenship questioned and could be stripped of their citizenship under the executive order.
Thank you. And if I could, in conclusion, because I see that I'm out of time, doing away with birthright citizenship is an intentional choice to give this president, I believe, massive power to dictate who is and who is not an American. I yield back.
Thank the gentlelady from Vermont. Now I'll recognize the gentleman from North Carolina.
Thank you, Mr. Chairman. Thank you for this hearing, and to all of you that are serving on this panel today. The issue of birth tourism is a big concern for me and stands out as a glaring example of a loophole being taken advantage of. Mr. O'Brien, in your testimony, you shared a little bit ago with Mr. Hunt about the national security risk associated with widespread birth tourism. what are among the top countries that are taking part in this practice? Where do they come from?
Well, the largest is China. The second largest is India. And then it drops off from there, but there's still large numbers of people from a large number of countries that we should have concerns about.
Very good. And aside even from the national security risk that you've already addressed, this practice puts many of those involved in coming here in harm's way. Can you talk about how the birth tourism can harm the expectant mothers involved in this?
Certainly, it's not advisable, at least according to all of the medical personnel that I've talked to, for women who are in an advanced stage of pregnancy to do something like a 14 to 24-hour flight from China. We have seen repeatedly along the southern border people who are traveling in extremely harsh environments, attempting to cross the Rio Grande while expecting a child imminently. And so this is a danger to both the mother and the child.
Thank you. I'm also curious, while we're here, Mr. O'Brien, about the comparison between how the United States treats this concept of birthright citizenship when compared to the rest of the developed world. Is it common for other countries to automatically grant citizenship to those born on their soil?
No, it's not common. It's something that's most typically associated with the United States, Latin America, Canada, and a few other countries that have extremely truncated variations of it.
And how would you say America compares to most EU countries in regards to this issue?
It's profoundly more broad. Most countries that have birthright citizenship have significant restrictions on it compared to the United States.
Very good. Mr. McCotter, I'd like to hear from you about how Congress can play its part in this conversation. I mean, it's one thing for executive orders, it's another thing for court decisions and interpretation. What steps can Congress take to support President Trump's executive order?
I authored an amicus brief on behalf of many members of this committee, and we submitted that in almost all the district court proceedings and in several of the circuit court proceedings, so the court is at least aware of these members' views on the historical understanding of the jurisdiction clause. That's one thing, of course, Congress could do. Congress obviously could hold a hearing, which we're having now, and I'm glad to participate.
Well, I'm proud to be a co-sponsor of Representative Brian Babin's Birthright Citizenship Act of 2025, which does clarify which individuals automatically receive American citizenship at birth. In fact, I've told folks if ever there's a time for us to clarify and codify, that time is now. Would you deem it necessary that Congress clarify this question surrounding the citizenship clause, or should it be left to other institutions?
The Supreme Court has long held that the decision of citizenship is left to Congress, except, of course, as dictated by the 14th Amendment. The courts can interpret the 14th Amendment as they're doing now, but otherwise it is exclusively a congressional prerogative.
So we do have an opportunity now, and with the act introduced, to take some action on this. And with that, Mr. Chairman, I yield back my time.
I thank the gentleman from North Carolina. I will now recognize the gentleman from Maryland and the ranking member of the committee.
Mr. Chairman, thank you very much. And thanks to all the witnesses for being here, and special greetings to my former colleague, Professor Frost. I want to start with you because there's been a major flurry of litigation about the onslaught of unlawful and unconstitutional executive orders that have come down from the administration. And this executive order has appeared in 4 different courts. And as I understand it, all 4 of them have worked to stop it, either through a temporary restraining order or a preliminary injunction. And they were appointed, by my count, by Presidents Reagan, George W. Bush, Barack Obama, and Joe Biden, 2 Republicans, 2 Democrats. And take a look at what they said. Here's Judge Kuhnauer, who was nominated by President Reagan. Citizenship by birth is an unequivocal constitutional right. It's one of the precious principles that makes the United States the great nation that it is. The president cannot change, limit, or qualify this constitutional right by executive order. I can't remember a case that presented a question as clear as this, says Judge Kuhnauer. And the fact that the government cloaked what is in effect a constitutional amendment under the guise of an executive order is equally unconstitutional. The Constitution is not something the government can play policy games with. Here's U.S. District Judge LaPlante from New Hampshire, who'd been nominated by President Bush. The plaintiffs are likely to suffer irreparable harm if the order is not granted. Here's U.S. District Judge Deborah Boardman, nominated by President Biden to the court in my home state, in Maryland. The executive order interprets the citizenship clause of the 14th Amendment in a manner that the Supreme Court has resoundingly rejected and no court in the country has ever endorsed. And finally, check out Judge Sorokin, nominated to the district court in Massachusetts by President Obama, who says the 14th Amendment says nothing of the birthright citizens' parents, and efforts to import such considerations at the time of enactment and when the Supreme Court construed the text was rejected. No federal judge, to my knowledge, has upheld this executive order against legal attack. Tell me why you think there's such unanimity across the spectrum among the judges.
Well, first of all, the language is crystal clear of the 14th Amendment. There are thorny and complicated and broad and vague provisions of the Constitution, but the Citizenship Clause could not speak more clearly. That's what the court said in Wong Kim Ark. Its language is universal.
You know, I did a little research on this last night, and I found that the leaders of the writing of the first section of the 14th Amendment were Republicans from Ohio, right? John Bingham was described as the primary author of the Citizenship Clause by Supreme Court Justice Hugo Black, who said he was the 14th Amendment's James Madison, the second founder who most worked to realize the universal promise of Madison's Bill of Rights and Jefferson's Declaration of Independence. And another great Ohio Republican, U.S. Senator Benjamin Wade, insisted on making the Citizenship Clause perfectly clear to avoid any backsliding in times of high partisan feeling. He said, I've always believed that every person of whatever race or color who was born in the United States was a citizen of the United States. But by the decisions of the courts, there's been a doubt thrown over the subject. And if the government should fall into the hands of those who are opposed to the views that some of us maintain, those who have been accustomed to take a different view of it, they may construe the provision in such a way as we do not think liable to construction at this time, unless we fortify and make it very strong and very clear. If we do not do so, there may be danger that when party spirit runs high, it may receive a very different construction from that which we, the founders, put upon it. Now, so I wonder what you think Senator Wade might be saying about the debate today about whether it's okay just to throw away the first sentence of the 14th Amendment.
Yeah, he was remarkably prescient. He foresaw a future in which a future political party would want to take away citizenship and voting and political power from groups of Americans it didn't like and didn't view as fully American.
All right, I'm sorry to rush you along here, but the original purposes of the 14th Amendment remain perfectly clear for anyone who's an originalist, right? They wanted to stop the government from reconstituting a racial or ethnic caste system based on the inheritance of a subordinate or a superior legal status from one's parents. In post-Reconstruction America, nobody would ever become a slave or a serf or a legal outcast or a prince or a princess or a king or a count at birth, because everybody here would attain equal citizenship at birth. Am I capturing it correctly?
You are.
All right, I yield back to you, Mr. Chairman.
I thank the ranking member of the committee, and I will now recognize Mr. Grothman for 5 minutes.
I'd like to ask one of the three gentlemen on the right here, and I've had other committee hearings, so I'm sorry if I'm going over things we've already dealt with. But it says in the 14th Amendment that citizens are people who are all persons born in the U.S. and not subject to any foreign power. I mean, they must have had something on their mind when they said not subject to any foreign power. Does anyone want to comment on that, how that little phrase there, how that affects what the original drafters intended?
I addressed some of that in my opening remarks, sir. So I think the best understanding is that it referred to children who would be deemed citizens of their parents' home country as of the moment of birth.
Okay, and right now in this country, if your wife goes to Italy and has a baby, does she become an Italian citizen? Would anybody say that?
I'm not sure what Italy's laws are. I would defer to Mr. O'Brien on that. I can say that at the time of the 14th Amendment, for example, English citizens born in the U.S. would still be deemed English citizens, and that's why they would not be entitled to birthright citizenship.
Okay. There are a variety of other countries that have some form of birthright citizenship, none of them in Europe, Canada, but you mentioned, Mr. O'Brien, that that's a limited type of birthright citizenship. Could you elaborate on that?
Yes, in most of those countries, there are restrictions that require at least one of your parents to be there lawfully. In some cases, it's birthright citizenship combined with familial lineage. There's all different ways of doing this. What I can say unequivocally is that the United States is the only place that does it the way it's done here.
Okay, so if you would interpret it the way some people want it interpreted, you would say the United States would be a clear outlier in the globe.
Yes.
And would they have been a clear outlier in 1866?
Well, yes, because at that point, most other countries in the world were monarchies, and the monarch considered you to be something akin to property owing permanent allegiance. So regardless of where you were born, you could still be considered a citizen depending upon how you had left the country.
Of course, we have records of the debate at the time in 1866. There's a quote here from Senator Howard from Michigan, making it clear, I think, that he felt we were excluding people who are foreigners or aliens normally. Do you want to elaborate on that, what the drafters at the time thought?
Sure, I think the drafters at the time were concerned about the treatment of emancipated slaves during the Reconstruction time. Frankly, at that point in time, there was a relatively small number of people in the United States, and as I had stated in my opening remarks, the concept of illegal alien was not the same as it is now.
Was there any indication at that time that in the hypothetical that the opponents of President Trump cite today, was there any indication that the drafters of the amendment believed that if somebody just came here as a visitor or whatever, we talk about, people coming from China and landing in San Diego or whatever, that the equivalent would have resulted in people being a citizen? Is there any evidence of that in, 1865, 1866?
No, the court in Wong Kim Ark was very explicit when it said that it was referring to people who were residing in the United States with the permission of the government.
There's no evidence of any of the debaters at that time saying, whoosh, we're opening the door to become American citizen. Anybody who gets off, just gets off a boat.
No, and I think if you stop and think about the way the amendment was drafted, if that's what they wanted, they could have just left the qualifying statement out and said anyone born in the United States is a citizen. But they added subject to the jurisdiction thereof for a reason.
Exactly. It's in there for a purpose. It's an amendment to the Constitution of the United States. You wouldn't put that in there if you wanted anybody who just shows up to be, as a baby, to be a citizen, correct?
That's correct.
Okay. Do either of the others know any examples of other countries? Any other countries that have something this broad, just so we understand the way an average person thinks about these things?
Yes, I'll say that 32 countries have birthright citizenship, just like the United States, including Canada and Mexico.
Okay, Mr. O'Brien, I think she's saying something a little misleading there. When she says just like the United States, even though there are no European countries, are they, when they have birthright citizenship, just like the United States? I think what you told me is not true.
No, to the best of my knowledge, at present, there is some kind of limitation on birthright citizenship in all the places that have it.
Well, thank you all for tolerating me, and we'll send it back to the chair.
Thank you, gentleman from Wisconsin. I now recognize the gentlelady from California.
Thank you, Mr. Chair and Ranking Member. I think there's a quick video that I have.
You don't need to be a genius to realize that Trump's not talking about babies that come from Norwegian vajayjays. No, he wants to white out the Constitution so that he can whiten America. That's what he's planning to do here.
All right, I just thought since, the South Africans are in the news, I would play that. I had a question for you, Mr. O'Brien. Is the Equal Protection Clause part of the 14th Amendment, yes or no?
Yes, it is.
Okay, thank you. And Mr. McCotter, is the Due Process Clause part of the 14th Amendment, yes or no?
Yes, although each clause
Okay,
uses
thank
different
you.
language.
Yes, I do know, but thank you for that. I ask those questions because I have heard no objection from this body, no quarrel, no disagreement with the fact that the Equal Protection Clause and the Due Process Clause are embedded in the U.S. Constitution through the 14th Amendment. In fact, this country's president, that so many revere, has invoked the Due Process Clause on the regular, as he should, because it is his right. And he has in fact showed the country how due process works when applied without prejudice. If only it would work for the rest of us like that, but I digress. The point is those tenets are here to stay with birthright citizenship. So I want to talk about the times that gave rise to the 14th Amendment. It was 1868. There was the aftermath of the 4-year divisive, destructive Civil War that killed roughly 750,000 soldiers, or 2% of the population. Resistance in the form of Reconstruction, a massive tsunami in a soon-to-be U.S. territory that killed 70 people, and in the aftermath of the 1868 Louisiana Constitution, which gave black men the right to vote and a public education, you had Louisiana, the Louisiana Massacre, where black people were murdered trying to vote. As people would say from my hood in L.A., the white folks went cray-cray. And in spite of all of that, white congressmen showed up in 1868 to debate the 14th Amendment because in the midst of the madness and violence of the time, it was that important. And it passed with birthright citizenship, those 3 clauses. And these tenets forever changed this country. The 14th Amendment is a pillar of American law in a good way, and it has been for 160 years. Everyone recognizes that it should not be touched, that it is sacrosanct, even Justice Scalia. And Scalia, whose ideology I do not support, his reasoning is that the full 14th Amendment, which includes the Due Process Clause and the Equal Protection Clause, as well as birthright citizenship, was based on originalism, textualism, and traditionalism, and that one should consider the political and intellectual climate, beliefs and prejudices of the time it was ratified, and the amendment should be protected, which is why it is worth revisiting 1868, because the origin story of the amendment is as applicable now as it was then. You had a Democratic president impeached in 1868 and a Republican president impeached in 1921. You had political violence in 1968 with the Louisiana Massacre and an insurrection that happened here in 2021 where Capitol Police were speared with American flags. You had a tsunami in Hawaii in 1868 and a fire again in 2023. You had an economic turndown in 1868 and you have $15 eggs under Trump right now in 2025. Same environment, toxic, hostile, destructive, deadly. And let's be clear, they had immigrants back then too. Irish, Jews, Germans, Italians, people who couldn't speak English, but they saw through the moment and passed the 14th Amendment. And it's not like this country has not had moments where people have felt under attack. We've had Jim Crow, World War II with the Germans, McCarthyism, the Japanese in internment camps, the Vietnam War, and birthright citizenship has survived all of that. And now, not because of war, but because somebody can't get a job at Walmart because of xenophobia, fragile ego, and mediocrity, we are going to look for culprits instead of protecting the Constitution. It is the epitome of lazy. And if they could put the 14th Amendment in the Constitution during those hostile times, we can keep it in law during ours. The climate is not different. It is the patriotism of the Republican Party that is different. And with that, Mr. Chair, I yield back.
Well, I would just observe for the record that the phrase white people be cray-cray is itself cray-cray. And I will now recognize the gentleman from California.
And also racist, of course. I was wondering how long it would take the Democrats to play the race card, and I want to thank my colleague from California for satisfying that curiosity. I think we can thank the Democrats under Joe Biden for bringing this issue to the forefront. The mass illegal migration over the last 4 years has made answering this question a necessity. Have those who've illegally entered our country in defiance of our laws and who are subject to deportation under those laws can they be considered as having accepted the jurisdiction of the laws that their very presence defies? I don't think it does. I mean, we know that phrase, subject to the jurisdiction thereof, we know that means former slaves are citizens. That was the stated purpose of the amendment. That's the plain language of the amendment, passed, by the way, over the objections of the Democratic Party at the time. We know from the congressional debate that its authors understood its meaning to exclude foreign nationals who were merely passing through the country, but somewhere along the way, it simply seems to have become assumed. So my first question, I guess, begin with you, Mr. O'Brien. Have any laws been passed that specifically provide for birthright citizenship for illegal migrants?
No, there have been none. And one of the reasons that this interpretation persists is because this wasn't an issue at the time that the case was decided, so it was left alone.
Well, how did it come to be that it was simply assumed?
Nobody knows that. When I was at FAIR, we did an extensive research project where we spent hours trying to find this. And we couldn't find any commentary on the Wong Kim Ark decision discussing the import. We couldn't find any government directives indicating that this was the rule. It just appears to have started happening in the mid-1920s.
Mr. McConnell, can you offer any light on this subject?
I think that's probably right. I think that's probably practicality. People weren't really paying attention, perhaps, and that's how we ended up with this kind of
So no act of
assumption.
Congress, no Supreme Court decision, obviously no executive order until a few weeks ago, touching on this subject.
Mr. McClintock, if I may just jump in here, I think the unfortunate reality is that the Wong Kim Ark case was misinterpreted in much the way I think that my friend Professor Frost here misinterprets it to have been a holding, some of the very broad language that is clearly dicta, instead of the narrow and specifically identified holding, which was quite limited to people who are in this country and their, who bear children in this country, who have a permanent lawful residents in this country, at least,
and it just kind of simmered,
established allegiance.
It just kind of simmered in the background until we had this mass historic illegal migration, and now we have to confront it. You know, the chairman says the issue belongs to Congress, and I'd say, well, sort of. Obviously, Congress can't deny automatic birthright citizenship by statute if that's what the 14th Amendment guarantees. But of course, neither could an executive order. I think Congress would have to propose a constitutional amendment to the states if that's what the 14th Amendment actually means. But if the 14th Amendment does not provide automatic birthright citizenship, and no statutes have been passed, and no other Supreme Court orders issued, it seems to me that no law would be needed to deny it. It was never extended in the first place. Is that, Mr. O'Brien, is that essentially correct?
Yes, that is correct. The question that Wong Kim Ark has been interpreted as addressing was never the question that was before the court. The case came before the court in order to determine whether Wong Kim Ark was an individual who fell into one of either the privileged or prohibited classes under the Chinese Exclusion Act, which itself was a modification of a treaty of trade and friendship between China and the United States.
They were here permanently within the laws, within the jurisdiction of the United States by act of a ratified treaty.
Yes, that's exactly it.
So if that's the case, and wouldn't the president's executive order simply be restating existing law?
I believe that's exactly what it does.
Mr. McCotter?
That's what my amicus brief on behalf of members of this committee says, sir.
Mr. Cooper?
I agree with that, Congressman McClintock.
I will just assume Professor Frost disagrees. That's it for me, Mr. Chairman. I yield back.
Thank you, gentleman from California. I will now recognize the ranking member, the gentlelady from Pennsylvania, Ms. Scanlon.
Thank you. You know, the effort to end birthright citizenship is hardly something new. It's been the long-term goal of anti-Semitic and white nationalist groups for decades. The claim's largely based on the bigoted Great Replacement conspiracy theory, same conspiracy theory that has inspired a lot of deadly terrorist attacks in recent years. And we're hearing really uncomfortable echoes of some of that here in Congress in this day and age. You know, as we're listening to some of these statements, I was reminded of one of our predecessor statements here, the great Barbara Jordan, who at a critical moment in our country's history talked about we the people. And when that document was completed in September of 1787, neither she nor I nor Professor Frost were included in that document. But as she said, through the process of amendment, interpretation, and court decision, we were finally included. And as members of Congress now, we should not sit here and be idle spectators, much less participants in the diminution, the subversion, or the destruction of the Constitution. And I would submit that the effort we're seeing here today to try to reinterpret and twist the clear language and legislative history of the Birthright Citizenship Clause would be such a diminution, subversion, or destruction of the Constitution. Now, Professor Frost, you've studied this for quite a long time. You, unlike several of the people here, are not a contributor to Project 2025. We've heard a lot about the specific language subject to the jurisdiction of. Why did they choose that phrase?
Yeah, the Reconstruction Congress told us clearly what they wanted to do there. They wanted to exclude the children of diplomats and ambassadors. And they also discussed at length the need to exclude children born into Native American tribes, which were separate foreign sovereigns with whom we had treaty relations with their own courts and laws.
It did strike me the inconsistency in claiming that an undocumented immigrant is not subject to the jurisdiction of the United States when they are, in fact, subject to our criminal code, paying taxes, et cetera. Can you talk about that and talk about how that relates to the issue of the exception for diplomats and their children?
Yeah, sure. Of course, all children of immigrants, and all immigrants, including undocumented immigrants, are subject to the laws of the United States. President Trump knows that better than most, in that he is seeking to deport and enforce the immigration laws and other laws fully against this group. Also add something I mentioned before, which is the Reconstruction Congress was well aware there were people in the United States in violation of the law. Those were the enslaved African Americans brought to the United States in violation of federal law, and of course, the Citizenship Clause was intended to provide them with citizenship despite the fact they were there in violation of U.S. law.
I noticed you reacting to some of the testimony about the U.S. being some kind of outlier with respect to birthright citizenship, or having, it looked like you might have a different interpretation. Can you expand on that?
Yeah, with all due respect to Mr. O'Brien, who is a deep expert in U.S. immigration law, I don't think he is familiar with the laws of the 32 other countries that have birthright citizenship, automatic birthright citizenship, just like the United States. In Canada, if you're born in Canada, regardless of who your parents are, you're a citizen. That's why Senator Ted Cruz had to renounce his Canadian citizenship in 2014, because he was born in Canada to a U.S. citizen mother.
Thank you. I also was struck by the idea that we would be putting a rather strange burden upon our maternity wards in our states if every time someone is born, they have to determine the citizenship or the immigration status of their parents. And how would that play out? I mean, does the delivery nurse have to ask which border the person came across, whether or not they checked in, whether they filed an asylum claim, or whether maybe they just overstayed their visa to study here if they were, for example, from South Africa? Do you have any thoughts on that?
It would impose enormous bureaucratic burden on hospitals, on state agencies, on our already overburdened immigration officials, and on the parents of newborn children. And as an immigration lawyer, I will say many people lack documentation of their citizenship or of their immigration status if they're lawful permanent residents. They may not be able to show that. And so we are asking these people at the time of their child's birth to prove this or risk having their child be deemed an undocumented immigrant from the moment it's born.
Okay, I do think it's interesting that this is hardly the open and shut case that our colleagues would suggest. Senator Cruz was recently quoted as saying that's actually a disputed legal question. There are serious scholarly arguments on both sides, et cetera. But with that, I see my time has expired, so I would just have a unanimous consent request to enter into the record a statement of the Leadership Conference on Civil and Human Rights.
Without objection.
Thank you. I yield back.
Thank the gentlelady from Pennsylvania. I will also, without objection, ask to insert in the record a collection of quotes from the gentlelady from Texas, Ms. Jordan. The airport bears her name. I fly in and out of in Austin, Texas, every week. But it's a collection of quotes from her service as chair of a commission regarding immigration in the 1990s, in which she makes very clear her position that the enforcement of borders security is important. The importance of having immigration policy that works is important, that we should not have amnesty, that we should, immigration should not be a path to public benefits. She was very clear in her language about that. And numerous other quotes from the gentlelady from Texas, Ms. Jordan. And without objection, I'll insert that in the record. And I will now recognize the gentleman from Missouri, Mr. Onder.
Thank you, Mr. Chairman, and thank you to the witnesses for being here today. My colleague from Pennsylvania mentioned the term white nationalism, and I would remind everyone of the context of the 14th Amendment, that the original white nationalists, Southern Democrats, fought a civil war to deny blacks their constitutional rights, to deny their very humanity, and then in the wake of that civil war, sought to deny them of the rights of citizenship as well. And in that context, the 14th Amendment was enacted to make sure that white nationalist Southern Democrats not deny black slaves, former slaves, of their rights, and therefore made it clear they were citizens. But Mr. McCotter, one of the authors of the 14th Amendment, Senator John Bingham, said that the Citizenship Clause conferred citizenship to every human being born within the jurisdiction of the United States of parents not owing allegiance to any foreign sovereignty. Another author of the 14th Amendment, Senator Lyman Trumbull, stated that subject to the jurisdiction of the United States in the Citizenship Clause meant not owing allegiance to anybody else. Do aliens, and particularly illegal aliens, owe allegiance exclusively to the United States, or do they still bear allegiance to their home country?
They would still bear at least partial allegiance to their home country.
And therefore, in part, foreign ambassadors, diplomats, do not have, children of foreign ambassadors and diplomats do not have birthright citizenship.
That's correct. And this came up earlier in some prior questioning about how LPRs, lawful permanent residents, could somehow be included within the birthright citizenship clause. And I think the response to that is that Wong Kim Ark itself recognized that those individuals do have sufficient allegiance, but that's because they're here permanently with the consent of the United States.
Okay. And, an example of, sort of the absurdity of all-out birthright citizenship, El Chapo's wife, Emma Coronel, traveled to California to give birth and then immediately returned to Mexico. Under Biden's policy, the children of a drug lord were then American citizens who had every right to American bank accounts, and indeed they obtained American bank accounts. Did El Chapo's children, did they own full allegiance to the United States?
They would not, no. Their children would have been at least partially allegiant to their parents' home country.
And so it is that, and I think in your testimony it's very clear that this idea of full allegiance is pivotal here.
It was the widely understood understanding of the jurisdiction clause at the time it was ratified, yes.
Okay.
And if I may just briefly respond to the claim that some of the arguments in this area are inherently racist in some way, I'd point out in Wong Kim Ark, Justice John Harlan, the sole dissenter from Plessy v. Ferguson, the patron of interpreting the Constitution as colorblind, he dissented in Wong Kim Ark and said that Wong had never become a U.S. citizen.
Yeah, and likewise, if I recall, it was what Filer v. Doe, in which Justice Brennan, in dictum, in a footnote, opined that that anyone born physically in the United States be a birthright citizen. Does dictum have the same force of law as a holding in a case?
It doesn't, and also in that footnote, Justice Brennan said that jurisdiction, the phrase jurisdiction, is bounded only, if at all, by principles of sovereignty and allegiance. The exact same things we've already talked about.
Which is what you're arguing today. Okay, thank you.
The gentleman yields. All right, I appreciate that. I will now recognize myself for 5 minutes. And I would just ask, Professor Frost, we talked a little bit earlier about the extent to which we've got the record is replete with examples of tourism, birth tourism, in which there are, malactors who are profiting by moving people into, or transporting people into the United States to then deliver babies. So we have Georgetown Law report talking about women from foreign countries, China and Russia, paying tens of thousands of dollars to temporarily relocate to the United States, give birth, and then often return. We have that happening at the southern border with some regularity. In McAllen, we have it in Laredo, we have it in El Paso, throughout Texas. I certainly can attest personally. You believe that all of those children, regardless of why they end up on American soil, that those children are, in fact, U.S. citizens under the law?
I'm so glad you asked that, because there's actually a federal regulation, 22 CFR 41.31, which bars people from coming to the United States to give birth and gives consular officials the authority to bar anyone visibly pregnant from giving birth.
But that's not the question. The question is these babies are born on American soil. These babies are born on American soil. They are brought here. They're brought here for profit. Are they citizens, yes or no?
Yes, they're citizens, and if you have a problem, enforce the regulation.
So the question is that they are, in fact, citizens under your interpretation of the law. Mr. McCotter, you noted just a minute ago that, in fact, Justice Harlan was the lone dissent in Plessy, correct?
That's correct, yes.
But was also a dissenter in Wong.
Right, he joined the Chief Justice.
So a threshold question here is, with respect to Wong, which is often cited as the basis now 130 years hence, for these individuals being viewed as citizens by now, in this instance, the most pernicious models, where people are profiting for bringing people into the United States to have babies, exploit our laws, go back to their countries, or exploit our laws for citizenship, that they are deemed citizens based on an interpretation of an opinion 130 years ago. Yes or no, Mr. McCotter, do you believe that Wong stands for that premise?
I do not, and I cite support for that in the brief.
You believe that it is limited to, at most, an LPR type status under today's law?
Right, here's a quote. Wong, by its facts and some of its language, is limited to children born of parents who at the time of birth were in the United States lawfully and indeed were permanent residents. That's from a professor at NYU.
Mr. Cooper, do you share that view?
I do share that view, and I would point out again that Wong itself conditioned its irresistible conclusion from the 14th Amendment. It affirms the ancient and fundamental rule of citizenship by birth within the territory in the allegiance and under the protection of the country, which was premised in that case on the parents of Wong being lawful permanent residents, allegiant to this country.
So to be clear, Mr. Cooper, you do not believe that that Wong's opinion extends, certainly at a minimum, beyond, again, what we would characterize under today's law as an LPR status individual?
No, it clearly just didn't have anything to do, as Mr. O'Brien has said, with illegal aliens or aliens here who may be here lawfully, but only temporarily.
And are you aware of any opinion by the United States Supreme Court that has extended beyond that interpretation since Wong?
No.
Mr. McCotter, do you agree with that?
I agree, yes.
Mr. O'Brien, do you agree with that?
I do.
And so now, having, I think, established that that is, in fact, the state of the law with respect to Wong and everything since Wong, now my question is Wong itself correct? We have an opinion by Justice Harlan, who was the dissent in Plessy, Was Plessy later overturned? Mr. Cooper?
Yes.
Mr. McCotter?
Yes.
Overturned. Mr. O'Brien?
Yes.
Professor Frost? Plessy was overturned.
Yes.
Now we've got Wong. Is Wong itself correct on the law with respect to even LPRs under the interpretation of the 14th Amendment? I would ask Mr. Cooper your opinion on that.
Well, I will tell you, Mr. Chairman, that I think there's significant support for the conclusion, the holding in Wong, in the debates under the Citizenship Clause. But one doesn't have to conclude that it is correct in order to uphold this executive order, because the executive order is entirely consistent with Wong.
Mr. McCotter, do you have anything to add to that? Mr. O'Brien, and then I will be done with my time.
No, sir.
Mr. O'Brien, anything to add?
I do not believe it was correct, and I would go so far as to say that the holding itself should be considered limited to the terms that were before the court, which had to do with a treaty with China, which is no longer in existence.
I appreciate it, gentlemen. We now have another member of the committee, and I will recognize my colleague and my friend from Texas, Mr. Gill.
Thank you, Mr. Chairman. 160 years ago, Democrats were asking us, if it weren't for slavery, who would pick our cotton? And today they're asking a similar question, which is, if it weren't for mass migration, who would pick our avocados? It's a similar pattern that they've established. You can say that the United States is not, in fact, better off by importing a massive class of what is virtually serf labor, which undermines our cultural fabric and our government as well. I'd also like to point out that the admission that we need more and more unvetted illegal aliens pouring into our country is also an admission that the goal, or one of the goals, of our colleagues on the other side of the aisle is explicitly to reduce American wages, because that's exactly what they're doing and what they're saying they're doing whenever they talk about bringing in cheap labor. We're talking here about birthright citizenship, and which has provided an enormous loophole in our immigration system and has facilitated the mass importation of illegal aliens. Through this current loophole, upwards of 300,000 people a year are granted automatic citizenship in the United States, despite being born to parents who have no ties to our country and who are here illegally. And also due to failures in our legal immigration system, these individuals then use their citizenship to sponsor their illegal alien parents and other family members for a green card, which creates a never-ending cycle of people coming into the country who have no business being here at all. We've now gotten to the point where the percentage of America's foreign-born population is quickly approaching 15%, which is the highest it's been since at least 1910. Mr. O'Brien, I'd like to start with you with a couple questions, if you don't mind. Under the 14th Amendment, Native Americans, due to tribal allegiances, were not granted citizenship. Is that correct?
That's correct.
Got it. And the children of foreign diplomats were also expressly excluded from birthright citizenship.
That's correct.
Got it. From the available evidence, is it safe to say that the authors of the 14th Amendment understood a difference between total allegiance to the United States compared to simply being subject to the legal jurisdiction by nature of presence in our country?
Yes, I think they made that very clear in the debates.
Got it. And in your opinion, based off this difference, would the authors of the 14th Amendment conclude that an individual whose parents did not owe total allegiance to the United States be granted birthright citizenship?
No, I think the import of the holding in Wong Kim Ark was that only individuals who were lawfully present in the United States could transmit citizenship to their children born, or I should say, only the children born of people who were lawfully present in the United States could acquire citizenship at birth.
Mm-hmm. And despite all this, some of my colleagues here still contend that essentially any person born here, regardless of their legal status or the legal status of their parents, have a constitutional right to become a United States citizen. Have you seen any evidence to suggest that the authors of the 14th Amendment would support that view?
No, and I don't think the authors of the opinion in Wong Kim Ark would have supported it either.
Got it. Thank you very much, Mr. Chairman. I yield my time back to you.
Well, I thank my colleague from Texas. I would now recognize the gentlelady from Pennsylvania for a unanimous consent request.
Yes, I seek unanimous consent to introduce Barbara Jordan's obituary in the New York Times from January 18th, 1996, in which it notes that she spoke out against a proposal to deny automatic citizenship to the children of illegal immigrants, saying, I quote, "To deny birthright citizenship would derail this engine of American liberty."
Without objection? And I would ask consent to insert into the record the amicus brief that was submitted by a number of House colleagues. It was drafted by Mr. McCotter. I would also like to introduce into the record a note that was written by Amy Swearer from the Heritage Foundation, who has written extensively on this issue, and also a op-ed that was written by Mr. Cooper, along with Pete Patterson, on this subject as well. Without objection, I'll insert that in the record. That concludes today's hearing. We thank the witnesses for appearing before the subcommittee today. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. Without objection, the hearing is adjourned.